judgment in the appeal in the matter of L and B children.
The judgment in this case will be delivered by Lady Hale.
It is a judge's job to make up her mind. But what is she to do if, having announced her decision, she becomes convinced that it is wrong? Is she allowed to change her mind? The question arose in care proceedings about a baby who had suffered serious non-accidental injuries, for which either the mother or the father was responsible. The fact-finding hearing spread over several days, separated over some months, because the mother suffered from a serious mental illness, which meant that she could not give evidence in the usual way. A few days after the hearing had ended, the judge gave a short oral judgment, quote, the December judgment, finding that the father had caused the injuries. The father's counsel asked the judge to give a fuller explanation on certain points. A further hearing to decide upon the baby's future was due to take place on the 20th of February. But a few days before that, on the 15th of February, the judge delivered a fuller written judgment, quote, the February judgment, holding that she was unable to determine whether the father or the mother was responsible. Unbeknown to anyone at the time, the order which the judge had made in December was not formally sealed by the court until the 28th of February. The mother appealed to the Court of Appeal, which, by a majority, held that the judge should not have changed her decision and ordered that the December judgment should stand. The father appealed to the Supreme Court. The Supreme Court unanimously allows the appeal. There is no general power in a judge to review his orders unless statute, regulations, or rules give him an express power to vary or discharge a previous order. But there has always been power to reconsider an order before it is perfected, nowadays by being sealed by the court. Hence, the judge did have power to change her mind. Previous cases in the Court of Appeal had suggested that this power could only be exercised in exceptional circumstances, but this is not correct. The overriding objective is to deal with the case justly. Each case will depend upon its own facts. In this case, no one had irretrievably changed their position on the basis of the December judgment. Finality was important, but the final decision had not yet been made. The judge should not be required to decide something as important as the future of a child on a basis which she now believed to be false. The court went on to consider what the position would have been if the order had been sealed before the February judgment. It is well established that in care proceedings, the final order is made at the end of the proceedings, and at that stage, the judge must be able to revisit earlier findings if fresh evidence or later developments indicate that they were wrong. The family proceedings rules give the court an express power to vary or discharge an earlier order made in the course of the proceedings. However, it may be different if the later development is simply a judicial change of mind. On the one hand, the court's paramount consideration is the welfare of the child. The decision is so momentous that the court has to get it right for the child. On the other hand, the whole purpose of holding a preliminary fact-finding hearing is to establish a platform of established facts from which the assessment of the child's welfare can proceed. This would be undermined and the later hearings thrown into disarray if the judge were in effect to hear an appeal against himself. As the arguments are so finely balanced on this point, the court declines to express a concluded view. The problem should not arise if the decision is fully reasoned, as unfortunately had not happened here. The court announced its decision immediately after the hearing, in order that the hearing to decide upon the future placement of the child, fixed for the following week, could proceed. Today, the court gives its reasons for its decision, and fortunately has not changed its mind in the meantime. We were glad to be told that the parties have reached agreement about where the child is to live and wish them well for the future.